Okay, yeah. So we're a research group within psychology. We've got SSSH members outside psychology, outside Leeds Beckett, and also outside academia, and that's really important to us. But all the work of the group members is underpinned by a commitment to preventing sexual harm and to destigmatizing consensual ethical sexualities. So if that is of interest to you, then you can reach out to us and come along to some of our meetings. We're also trans-inclusive, anti-racist and supportive of sex workers' rights. That's really important to us. And we're interested in engaging with practitioners, artists and activists. We've got an activist in residence at the moment called Jen, who is helping us to disseminate some of our findings in interesting and more accessible ways. And we're also hoping to have some non-academic practitioners, artists and activists deliver some seminars for us, which would be really nice. So to introduce Tanya, she is an associate professor of law at the University of Sussex and also the co-director of the Sussex Centre for Gender Studies. Tanya's research is primarily concerned with the legal regulation of sexual encounters, particularly through the criminal law. Her current and recent work covers topics including critiques of the consent standard in sexual offences law, sex work, extreme pornography, the intersection of sexual and domestic abuse, legal responses to rough sex, and legal responses to rape by deception. She's a co-investigator on the online sperm donation project, working with colleagues here at Leeds Beckett, and there's also other colleagues from around the country and the world actually working on that project. And she's currently working with colleagues at Sussex to develop training for HE students on sex, consent and harassment. And today, Tanya is going to be talking to us about some ideas from her forthcoming book, which is called Renegotiating Sex and Sexual Violation in the Criminal Law, which is under contract with Heart Publishing. So without further ado, we'll hand over. I'll just switch these slides over. Okay. Yay. Different from what it looks like.
Hi. So, as Jessica said, I'm based in the law school at Sussex. So my sort of disciplinary background is primarily in law, socio-legal studies, and within that, primarily criminal law, which I would say I have a sort of a slightly fraught relationship with, in the sense that on the one hand, like, criminal law is what I know, it's where my expertise is, I know kind of how it operates and how to do things with criminal law, and at the same time I'm quite sceptical of the criminal law and criminalisation as a solution to most things, and you know, I think there are some areas, particularly around sex work, where, to me at least, it feels much more straightforward to say criminal law is not helping here, we just need to strip it back. Whereas with some of the stuff that I'm looking at today, I think there is a role for the criminal law there, and there's something to say about that. And although I'm based in law, I try to work in a sort of relatively interdisciplinary way, and bringing together the more sort of legal doctrinal stuff with more theoretical stuff, as well as some empirical work. And the kind of the central question that I've been investigating in my research for the last 15 or so years is how we distinguish sex from sexual violation, both in terms of a sort of ethical standard and then in terms of how the law should enforce that standard. This work has been variously funded by the ESRC and the Leeds Trust. So the ESRC funded my PhD and a postdoc at Bristol, and then I had a Leeds Research Fellowship a couple of years ago, both of which have sort of funded parts of the development of this project that I feel like I've been working on since the dawn of time. And as Jessica said, I'm currently working on a monograph with the not such a catchy title of Renegotiating Sex and Sexual Violation in the Criminal Law. And really, sort of one of the part of the kind of core argument of the book is that consent doesn't work, that it is fundamentally flawed, both conceptually and practically, as a model for distinguishing sex from sexual violation, and we need to replace it with something else. So what I want to do in this talk today is start by exploring in slightly more abstract terms why I think consent doesn't work, why it's a flawed mechanism for answering that question. And then I want to introduce the concept that I've called freedom to negotiate, which I'm proposing as a sort of new alternative to consent. And then what I want to do is explore how a shift from consent towards a freedom to negotiate standard can help us to draw the line between sex and sexual violation in a number of kind of particularly tricky or difficult contexts. Just by way of content note, probably fairly obvious from the title of the talk, but I will be sort of talking in detail about a few specific examples of sexual violence. Okay. So, consent doesn't work. I mean, consent is very much the dominant paradigm for distinguishing between sex and sexual violation, both within law, certainly within England and Wales, but with many other jurisdictions throughout the world, and beyond the law as well, right? In sort of popular or lay discourses, there is a real kind of consensus around consent, a sort of shared understanding that, you know, sex is okay, provided everyone involved consents. And I think there are good reasons why this model is popular, why it feels so appealing, particularly when we think about some of the alternatives and some of the ways that sort of legitimate or appropriate and inappropriate or unlawful sex have been conceptualized previously, particularly using models that are more sort of force-based or models that define acceptable sex around a sort of conservative morality. So a consent standard looks really good compared to either just allowing people to do whatever they want to each other. It looks really good compared to a model based around physical force that sort of defines what counts as sexual violation really narrowly and really misses or overlooks a lot of people's actual lived experiences of sexual violation. And as I said, it also looks really good compared to frameworks that only legitimize sex that fits a kind of conservative moral framework. So, you know, if you think up until the late 60s in this jurisdiction, it was a crime for two men to have sex with each other. In some jurisdictions, adultery is criminalised. In others, various forms of non-procreative sex are criminalised. So in the States, for example, some of the sodomy laws that are still on the books are partially aimed at criminalising sex between men, but are also criminalise any sex that doesn't fit a sort of narrow heteronormative procreative ideal. So compared to all of those kind of approaches, consent is doing something right. But I would argue that it's nevertheless flawed as a model for distinguishing sex from sexual violation. So why? First reason is the ambiguity, right? So although we've got this kind of quite wide consensus that consent is an appropriate dividing line between sex and sexual violation, you know, this idea that sex is ethical and should be legal provided everyone involved consents, most people can kind of agree on that and get on board with that. Once we start to drill down into, okay, well, what do we actually mean by consent? then we start to see the sort of differences and the disagreements creeping in. And it becomes much harder to actually pin down what counts as consent and what doesn't. And we'll see that particularly in some of the kind of particular contexts and examples that I'm going to look at later on. But within a lot of the academic literature around consent as well, we get all these questions coming up around sort of, whether consent is an internal mental state, or is it some kind of externalized utterance or gesture? If the latter, does it need to be given verbally? Do we need sort of affirmative consent? And if so, what kind of affirmation? Does it need to be enthusiastic consent? And to what extent does consent need to be informed for it to count? And what forms of coercion will vitiate a sensible consent? Now, the Sexual Offences Act 2003 took some steps to try and address that ambiguity. Right? We get the introduction of a statutory definition of consent for the first time. So it's now defined in law as agreement by choice with the freedom and capacity to make a choice. That also raises lots of questions like, okay, well, what counts as freedom? How much freedom? When do you have capacity? What is a choice? So it doesn't necessarily get us that much further. The Act also introduced various the sort of lists of presumptions. So it lists specific scenarios in which we can presume that consent was absent. So a few examples from the Act where the complainant was unconscious or didn't understand that the thing they were agreeing to was a sexual act, or where they were being threatened with violence at or immediately before the sexual activity took place, for example. The Act explicitly tells us that in these circumstances we can presume that that person wasn't consenting. So there is there is more guidance within the law itself than there was 30 years ago. Nevertheless, there's still a lot of scope for disagreement and confusion over what does or doesn't count as consent. So that's one of my issues. My next sort of issue or critique working with consent is some of the ways in which, particularly in sort of Anglophone legal jurisdictions, it has become very enmeshed with a sort of liberal concept of this rational disembodied self. And so what that ends up doing is to kind of centre the wrong of sexual violation on quite a narrow, individualistic, proprietary version of autonomy. So it thinks about, we sort of end up conceptualising non-consensual sex as a violation of this quite sort of abstract right to choose and to choose what happens to your body, which then has a tendency to sort of marginalise or render invisible the bodily, affective and relational dimensions of sexual activity. And, these are things that are quite central to why sex matters to people, certainly in some of the empirical work that I did, my research participants, were sort of touching on all of those kind of things, those relational dimensions, those affective, emotional dimensions, as really central to why sex is important, why it's something that matters, why it's something that we should kind of care about, whether that's done to people without their agreement or willing participation. And that gets kind of slightly pushed to the side when we just think in quite a limited way about sexual autonomy and just think of it in terms of sort of the act of kind of making a choice. I think as well, sometimes caught up with that framework, we can end up sort of emphasising the policing of bodily boundaries. So in a way that means prospective partners are either sort of a threat, someone who might violate those boundaries, someone who might violate your lack of consent, or an obstacle to be overcome, right? Oh, I need to get that person's consent before I can do the thing that I want to do. So it becomes quite sort of individualizing rather than thinking about sex as something that is sort of co-produced, that is people creating an experience together. And what that also means, particularly in a kind of legal context, is we end up with quite sort of individualized inquiries into an individual complainant's state of mind, and that kind of focus on and scrutiny of the complainant rather than the defendant's behaviour. So, third issue is the asymmetry of consent. And what I mean by this, and you know, to an extent, this isn't inevitable, right? Consent, I'm not a scholar of Latin by any means, but my understanding is the roots of that word are around sort of fellow feeling or feeling together, right? Con meaning with and sent meaning feeling. So it didn't have to go down this sort of individualistic route or this asymmetric route, but that seems to be where we have got to in this particular place and time. And so the way that consent has been understood and operationalized tends to encourage us to think about sex as something that sort of one person proposes or initiates, and then the other person either consents to or refuses. And this sort of asymmetry is in turn gendered, because we have these kind of strong cultural associations between masculinity, penetration, sexual assertiveness, or even aggression, and between femininity, passivity, and openness or viability. Well, that is obviously not to say that women never initiate sex, or that men are never sexually violated, not at all, but rather that when people do take those different positions, it stands out, right? There is more of a cultural pressure not to organise your relationships in those ways, or your activities in those ways. And I'm thinking as well about some of the ways that this comes through, even in sort of quite well-meaning sex and relationships education and education around consent. You know, if boys are always told, you've got to get consent first, and girls are reassured that it's okay to say no if you don't want to do it, we're still sort of perpetuating that idea that sex is something that men do to women. And even, you know, if we think about that kind of shift from the sort of feminist slogan of no means no to yes means yes, that's still answering a question, not being the one who's kind of asking it. So, you know, it still kind of positions consent as this sort of reactive form of participation, this kind of quite minimal reactive way of choosing. I also think, and this is in a sense maybe the sort of more positive flip side of that same coin, that this is quite disconnected from the reality of how people actually negotiate their sexual encounters, right? Most people, I'm thinking of like Melanie Barris's work in particular, who did lots of empirical work with people about how consent actually plays out for them in their sexual encounters. And for the most part, people don't have this kind of moment where they say, I would like to do this to you, and the other person says, yes, please, I agree to 1 unit of sex. So, you know, it doesn't really look like that in practice. This isn't really mapping on to how people live their lives or how they conduct or negotiate their sexual encounters. And because of that, because sexual encounters are sort of variable and amorphous and developing, I think they're not that well suited to this kind of consent structure. a couple of examples I've used in some of my published work, which I've mentioned at the bottom there, is like things that you could consent to, right? Things that are really specific and fixed in form, like a direct debit, for example, right? I can consent to my bank taking X, or maybe a standing order, even more clear and fixed. I can consent to my bank taking X amount of money out of my account every month. You know, there are very clear parameters agreed to in advance. And there's a sort of clear asymmetry there as well. I'm giving my permission for the bank to do something. That feels like that works nicely and easily. Another example, I might consent to someone borrowing my car. If I had a car, I might do that. And with that, you know, things are a bit more fluid, right? Some parameters are probably going to be agreed in advance. I know when they're going to pick it up, how long they're going to have it for. I probably know roughly what they're going to use the car for. But the finer details, you know, which specific roads they're going to drive down, how fast they're going to go at any particular point in time, I'm kind of leaving that up to them. Again, consent feels like an appropriate way to describe that. Right? I am agreeing to, giving permission, consenting to them taking the car. And yeah, we've agreed some parameters in advance, but the rest of it, I'm consenting to them making those decisions. Sex isn't really like either of those examples, or at least not usually. You know, we don't usually just sort of hand ourselves over to another party to do whatever they want. Some of us might in some circumstances, but often that isn't how sex proceeds. So those kind of finer details are, in a sexual encounter, are evolving and ideally are sort of mutually negotiated. And I think crucially, the parties to a sexual encounter need to be able to express something more than just a mere kind of willingness or lack of willingness to engage in the sexual activity. They need also to be able to negotiate the kind of quality of that encounter. So to express concepts like faster or harder, or not quite like that, or could you touch me there instead? You know, all of those kind of little granular things, which again, it's that kind of communication appears kind of peripheral under a consent framework that just focuses on, do you agree to sex or not? But actually is quite essential to real world sexual communication and negotiation. Finally, then, on my kind of issues or complaints around consent is the lack of context. So again, this isn't necessarily inevitable, but I think consent models tend to disregard the embodied, relational, and intersubjective aspects of decision making, overlook often the unequal power dynamics within which those choices are made, both at the level of sort of interpersonal relationships and at broader, more structural levels. I think, again, I'm obviously coming to this with a sort of lawyer's perspective. I think that's particularly true in the way that consent has been operationalised within the law, where although, particularly since the 2003 Act came into force, there is a bit more kind of scope to recognise context, the focus still tends to be on context kind of at the moment of or immediately preceding the sexual activity taking place. There's less scope to look at that sort of broader temporal or social context in which that sexual encounter is taking place and being negotiated. This becomes particularly problematic in the context of coercive control, which I will talk about a little bit more later on. Okay. So What I'm proposing as an alternative to consent is what I've called freedom to negotiate. And so I propose using this as a mechanism both for guiding our sexual ethics and for evaluating encounters after the fact and classifying them as either sex or sexual violation. And so under this framework, what I'm suggesting is that our inquiry shifts from did one person consent to sexual activity initiated by another person to did all the parties have sufficient freedom to negotiate both the sort of fact of and the quality of their participation in the sexual activity. I use the term freedom to negotiate rather than free negotiation because I think the space for negotiation is more ethically relevant than the form or content of the negotiation itself. So what's important is that all parties know they have the opportunity to express their desires and participate in shaping this shared sexual encounter, more so than how or even whether they actually express those desires. I also want to mention that when I use the term negotiation, I'm thinking of that, I guess, something like sort of negotiating the terrain, this sort of process, this movement, this kind of feeling your way through, as opposed to a kind of business negotiation that comes to a definitive end. And so the idea is that this new model, freedom to negotiate, would address some of the issues with consent that I've identified. I don't think it necessarily addresses them all, particularly the ambiguity problem might still be there, might need some more work to kind of flesh that out. But at the kind of fundamental or conceptual level, I think what a move to freedom to negotiate does is it's about understanding sexual encounters as something that are mutually co-produced by the parties rather than a kind of asymmetric one person proposes and the other person either consents or refuses, and that it would respond more to the fluidity of sexual encounters. So again, the idea that you don't just agree in a fixed moment of giving consent. And again, this is part of the reason for thinking of this in terms of freedom to negotiate rather than saying freedom to make a choice, which is referenced in that statutory definition of consent, to recognise, again, that this is kind of an ongoing thing. It's not a moment of making a choice, it's an ongoing space to participate in that negotiation. And on kind of the more practical side, particularly in a legal context, I think what this does is to provide scope for a more contextualised evaluation of the sexual encounter at issue and to shift us towards scrutinising the defendant's behaviour rather than the complainant's behaviour. So, whereas at present in a rape trial, our key questions are, did the complainant consent? So that's all about the complainant and what's going on in their head. And even if they didn't consent, did they do anything that might give rise to a reasonable belief that they were consenting? Again, we're scrutinising the complainant's behaviour as well. Whereas under a freedom to negotiate framework, our key questions become, did the defendant do anything to constrain the complainant's freedom to negotiate? Or did the defendant knowingly exploit some existing significant constraints on that complainant's freedom? So for the rest of this talk, I want to just look at what this shift means in practice through the lens of some particularly tricky cases or areas and think about how this freedom to negotiate model might help with making sense of some of those cases in a better way than consent does. So my first sort of area is around, said there, drunken consent, but we might think more broadly than that. Lots of cases involve drink or other drugs. Lots of sex happens while people are intoxicated. And while the legislation has a sort of a specific section addressing drink spiking, it's silent on the implications of a complainant's intoxication where they have voluntarily consumed alcohol or drugs. So this has been left for the courts to grapple with. And I think also, again, thinking beyond just the courts and that legal context, the ethics of whether and when it's okay to have sex with someone who has voluntarily consumed alcohol or drugs are tricky, right? It's sometimes suggested, this came up from some of my research participants, I've seen it come up in some consent education materials and also in some of the discourses around BDSM and kink. It sometimes gets suggested that sex is unacceptable unless all parties are completely sober. Now, that doesn't seem to me particularly realistic or even particularly desirable, right? Are we really saying that, a couple who go out to dinner and each have a glass of wine with their dinner are both violating each other if they then proceed to have sex otherwise? But that, just does leave open this tricky question of well, what are the implications for drunkenness or other forms of intoxication? How do we decide when it's okay to have sex with someone who might be under the influence? And so I want to explore the way that freedom to negotiate can shift our thinking around these kind of cases through the case of R and Bree, which is the leading case on intoxicated consent in this jurisdiction. And this is a case in which the complainant had been out drinking with her flatmate, his girlfriend, and his brother. And they were all students at the time. And the flatmate's brother, who comes out drinking with them, who's down to visit, is Benjamin Bree, the defendant in this case. They've all been out drinking, and at the end of the evening, they return to the flat shared by the complainant and the defendant's brother. And it's clear that the complainant and the other young woman who's present are considerably more affected by the alcohol than the two young men are. We're told, for example, that the complainant was continually throwing up and that Benjamin Bree helped her to wash her hair. According to him, she was then in a much better state and they proceeded fairly organically to have consensual intercourse. He stated that M, the complainant, indicated her consent non-verbally through encouraging moans and physical actions, such as removing her own pyjama bottoms after he put his hand inside them, and rolling onto her back and opening her legs. By contrast, M recalls quite a different experience. So she testified that she remembered sort of finding herself lying on the bed, unsure how she got there, at which point Benjamin performed a number of sex acts on her, including vaginal penetration. She spoke in her evidence about having the sensation that she wasn't in her body and feeling like it wasn't happening. She knew she didn't want any of the sexual activity, but lacked the physical coordination to do much to try and stop it, although she did say ow and roll up against the wall, which didn't stop him. Benjamin was charged with rape and found guilty by a jury in the Crown Court. So the jury seems to have believed and accepted M's version of events. But he then went on to appeal his conviction on the basis that the jury had been misdirected on the implications of M's voluntary intoxication. And that appeal was successful. His conviction was overturned. And in that Court of Appeal judgment, the court focuses primarily on what alcohol does to an individual's capacity to consent. At what point are you so drunk that you no longer have capacity? They accept that you reach this point before passing out, although there doesn't really seem to be much space between the level of intoxication of this complainant and complete unconsciousness. They accept that you might lose capacity before passing out, but that you can still consent even if you are drunk. So ultimately, this kind of consent-based framing of the case mandated quite an individualized focus on the complainant's mental and physical state. How drunk was too drunk for her to be able to consent? I think what a freedom to negotiate model can do here is it can bring to these types of cases a framework for recognizing the operation of power between the parties. So rather than asking whether M had capacity to consent as a sort of relatively abstract proposition, freedom to negotiate invites us to examine the relational dynamic between parties. To consider, for example, that not long before the sexual activity took place, Benjamin was considerably more lucid than M, more in control of his faculties. He was able to take care of another person, to wash her hair for her, while she was unable to wash herself, let alone take care of somebody else. So looking at the parties' capacities relative to one another, we might then ask how Benjamin could think that M was really free to negotiate a sexual encounter with him on any kind of equal footing. We might question whether his view that she seemed to be in a lot better state after she'd been sick was really enough for him to conclude this. Did he consider that she might not be best placed at that moment to communicate what she did or didn't want? Was he aware, and should he have been aware, that she may have been physically unable or too scared to resist him? So I'm not suggesting that freedom to negotiate necessarily gives us a definitive right answer to all of these questions, but I think it shifts us towards asking more ethically relevant questions about these types of cases, rather than just this very individualized focus on the capacity and the consent of the individual complainant, and particularly shifts us towards looking at the relational dynamic between the parties. Okay, next sort of scenario I want to raise is sexual activity in the context of coercive control. As I mentioned before, this is an area where context becomes really important. There are, I think, lots of issues with how we conceptualize and respond to sexual violation within abusive relationships. I'm just going to focus for today on what this kind of shift from consent to freedom to negotiate might do here. I think one sort of general point I want to raise about these relationships is something that comes up a lot in the sort of published literature and research in this area, is like victim accounts of their abusers demanding sex and then sort of reluctantly acquiescing to it. One of the things that becomes difficult with those demands under a consent framework is that often the sort of demand is made without any specific or direct threat attached to it, or the kind of consequences for that specific demand might be, oh, well, he's going to be in a mood, he's going to sulk, he might break up with you, these kind of things, which aren't necessarily enough, certainly in law, to kind of cross that threshold into making this compelled non-consensual sexual activity. But when we understand them in the context of coercive control, when we understand how terrifying a partner sulking can be when you've previously seen that escalate into a violent rage, or how difficult it might be to resist sort of badgering or pestering when you've been kept so sort of busy and exhausted that you just don't have the energy to refuse. So, I think there are key aspects of coercive control that get pushed to the side within a consent framework that's just sort of focusing on the moments immediately before and around the sexual activity, that mean and again, certainly in a legal context, can lose sight of why actually that threat is enough, or those potential consequences are enough to override that person's choice or override their freedom to negotiate. I want to look at this through the case of F&DPP, which I think illustrates a lot of these issues. So this is a Judicial review of the Director of Public Prosecution's decision not to prosecute ex-husband for multiple sexual offences that she had reported that he committed against her. So she reported her husband, great, he wasn't prosecuted, and she went to court to challenge that decision. And she was ultimately successful. And the basis of that judgment rests on one specific incident. So out of the many that she'd reported, the court focuses in on one incident in which she had agreed to have sex with her husband, provided that he wear a condom or withdraw before ejaculating, primarily because she didn't want to get pregnant again. He then deliberately ignored her wishes and did ejaculate inside her. So the judgment concludes that that behaviour would amount to rape, but the DPP was therefore wrong not to prosecute it as rape. But what I think is interesting here is the way that this judgment focuses on the idea that this kind of requirement to wear a condom was fundamental to F's consent, and so by overriding that specific condition, the defendant had violated her consent. And I think looking at the facts of the case kind of misses the point, right? F's statements, when we look at them as a whole, paint a picture of a continuous and developing pattern in which all sexual encounters between her and her husband came to be dominated by his sexual desires, while hers were erased or overridden. The sex he insisted on was often physically violent and humiliating for her. And when we look at these facts through a lens of freedom to negotiate, it seems that F didn't really have the freedom to negotiate whether or not to have sex with her husband at all. So her husband's repeated violence, intimidation, and control meant that she knew the costs of refusing him, even if they weren't explicitly spelled out on that occasion. And in this light, her plea that he wear a condom looks more like an attempt to manage the risk associated with a sexual act that she doesn't want to participate in at all, rather than a sort of conditional agreement to have sex that she desired, provided it went the way she wanted it to. I think something else that comes through in the facts of this case is the kind of deep sense of betrayal as well, when there were occasions where she did want to have sex with him. She wanted kind of intimacy with him. And she talks about sex kind of starting out intimately and then turning into this sort of rough and humiliating experience. Again, that's something that can't really be captured if we're just thinking in terms of did she consent or not. Whereas freedom to negotiate allows us to think more about what kind of sex did she want to have? Did she have any kind of opportunity to articulate or kind of advocate for the kind of sex that she wanted to have? So again, for sexual activity in the context of abusive relationships, I think the freedom to negotiate model can point us towards looking at what the defendant has done, both at the time of the encounter and within the wider context of that relationship, to constrain the complainant's freedom to negotiate both the bare fact and the more granular detail of her participation in sexual activity. Okay, next scenario I want to look at, and I'll wrap up with a few final thoughts. So the sort of rape by deception cases, I've put that in inverted commas because I don't think all the cases brought under this umbrella necessarily do involve deception. For any of you familiar with the case law in this area, you'll remember it is a mess. And there's certainly not scope to look at all of that in detail. But I think, again, these cases illustrate both the potential and some of the limitations of freedom to negotiate. So in these cases, the law and the scholarship has tended to get caught up in questions about what kinds of deception are allowed to matter, what deceptions is the complainant allowed to care about, does that complainant have a responsibility to articulate any particular deal breakers, and if so, what deal breakers can that complainant reasonably be expected to anticipate? Does someone need to say every time, by the way, I don't want to have sex with you if you're HIV positive? By the way, I don't want to have sex with you if you are secretly an undercover police officer. Which takes us on nicely to one of the two illustrative cases I want to look at. So Monica and DPP, the case concerned a sexual relationship between Andrew Boylan, who was at the time an undercover police officer, and Monica, an environmental activist and part of the movement that Boylan's undercover placement was set up to spy upon. Similar to F, this is a case where Monica reported rape, it wasn't prosecuted, and she then challenged that decision not to prosecute. In declining to prosecute, the DPP framed Boylan's deception as amounting to only to lies about his name and profession, which, incidental, merely provided the circumstances for them to meet, after which they developed a relationship based on mutual attraction. I tend to think Monica's description is more accurate. She describes the deception as going to every part of his identity apart from his body. So I would argue that she was deprived of the freedom to negotiate whether and on what terms she wished to have sex with Andrew Boylan, because she believed herself to be interacting with an entirely different person. I don't think it should matter that neither he nor his alter ego were previously known to her, or that that alter ego was completely fictitious. The law of presence focuses on impersonating a real person known to the complainant. But the court effectively decides that Monica's wish to not have a sexual relationship with someone who is lying to her about every aspect of his identity whilst surveilling her and her friends is not a wish that matters when it comes to establishing whether or not she consented to sex. We can contrast this with the case of McNally. Here, the defendant and the complainant met online at age 13 and 12. They continue that relationship online for a few years before they meet in person, by which point they're both over the age of consent and engage in various sexual acts. The defendant went by the name Scott, and the complainant believed that Scott was a boy. The complainant later finds out that the defendant was assigned female at birth and had been given the name Justine by their parents. And to me, this is a very different scenario to Monica. Right, the defendant here didn't create some whole fictitious persona and backstory. Scott and Justine are one and the same person, a person who used a name different to the one that their parents had given them. It's not that unusual, and dressed in a style that they felt comfortable with. These behaviours in and of themselves are not deceptions. But while Boylan, the undercover police officer, isn't even prosecuted, McNally is prosecuted, convicted, and imprisoned for the crime of assault by penetration. And while the judgment focuses on the defendant deceiving the victim by purporting to be a boy, it's not at all clear that that is a deception, right? Arguably, he is a boy. It's hard to kind of be able to talk about this with any certainty, because also we don't know how this defendant identifies now, and there are lots of reasons why they might not feel able to identify authentically after all of this. And you know, I don't want to sort of downplay or invalidate the sense of violation and betrayal and confusion that the complainant in that case experienced, but I would argue that perhaps that victim, as she was constructed by the courts, that her freedom to negotiate a sexual encounter with Scott, the person standing in front of her, whom she'd been getting to know over a period of years, wasn't actually constrained. What's challenging for me about this case is that the appeal court that upheld the conviction does frame their discussions using ideas that look kind of similar to freedom to negotiate. So they focus a lot on the idea of freedom to choose and decide that the complainant's freedom to choose whether or not to have sex with a girl had been removed by the defendant's actions. So I don't necessarily disagree with the framing of the questions here, but I do disagree with their interpretation. So again, like freedom to negotiate doesn't necessarily give us a complete or definitive answer here. Nevertheless, I do think it has something to offer to our thinking around these cases. It can sensitise us to the power dynamics at play so that we might look differently at the dynamic between two fairly inexperienced teenagers who are both trying to figure out who they are and how they want to present themselves in the world, versus the power dynamic between an environmental activist and a serving police officer with the full resources of the state behind him. Just as a kind of final area to highlight then, I've sort of picked those three examples to focus on for today, but there are lots of other kind of tricky areas where I think the consent framework is limited and freedom to negotiate can shift our thinking. Just to sort of say very briefly, I think with children and adults with a mental disorder, what we've seen historically in the law is the creation and proliferation of a whole suite of separate offences that deal with sexual activity with children, sexual activity with people with a mental disorder impeding choice, sexual activity between people with mental disorders and their carers, all of these different permutations. And that seems to be a sort of almost like a recognition or an admission that the consent framework can't quite deal with these kinds of relationships, can't quite work here. We need something else to deal with what's going on. So I think the existence of these separate frameworks in itself highlights the limited nature of a consent framework. But what we get by then sort of writing these people out of that main framework is a few sort of problematic things going on. Again, it's very individualized. There's a lot of sort of focus around adults with mental disorders and children sort of lacking capacity, and it's looked at as a sort of feature of them as an individual, rather than actually often it's the kind of social and environmental and relational dynamics that mean that these people have less power and less freedom to negotiate their interactions with others, including their sexual interactions. What it also means is that, on the sort of technicality of the law, we don't have a way to distinguish between, say, two 12-year-olds or two 15-year-olds having sex with each other, mutually desired sexual encounters between peers of a similar age. Technically, is exactly the same wrong as a 35-year-old or 40 or 50-year-old man having sex with that child. This, thankfully, usually gets dealt with by sort of prosecutorial discretion, but it seems sort of unsatisfactory that we don't have a way to conceptually recognise those differences. If we're just saying, oh, it's wrong because that child can't consent, but it must be wrong for more reasons than that. It can't just be wrong because of their lack of consent, because then it would be wrong regardless of who is having sex with them. I've also just left sex work sort of hovering in the corner there, which is probably the trickiest area for me, because on the one hand, I feel very certain that the existing prostitution offences should be removed, that it should be decriminalised, that a lot of the laws that in theory aim to address exploitation of sex workers actually put them at greater risk, and also that we need to sort of recognise and respect sex workers' own distinctions between different types of experiences, and particularly the ways that they draw lines between an encounter with a client that goes exactly as agreed, albeit they wouldn't have done that if they didn't need the money, versus an encounter with someone who violates the terms of that agreement and engages in sexual acts that they did not agree to. So I think there is then a difficulty there when at the same time I'm kind of saying, oh, we need to think more broadly about these types of coercion and the kind of broader like structural forces that constrain someone's ability to make a choice, when there are lots of sort of structural and other factors that constrain people's choices about whether to engage in sex work or not. So as I said, I've left that hovering as a tricky one that needs a bit more thinking through. My last thought, I guess, on that is that also built into this picture is needing to think about, well, how does the law itself constrain or open up the freedom to negotiate, open up that space for negotiation. I will finish there so that we can have some time for discussion. Thanks very much.
Does anyone have any questions for Tanya? I'm going to see if there's any online.
Maybe we might need you next time. Yeah. I know that I'm
quite happy to have a It is just water. It's the only bottle that fits in my little crossbody bag.
Thank you. I really enjoyed that. Sorry, I came in late. I know when we're talking about the drunken consent situation, and you're talking about the importance of considering being relative between the two.
Yeah.
And obviously in this case there was a clear difference in the degree of intoxication between the two individuals. I guess I'm wondering, do you have any thoughts on what would be the considerations if you thought that both individuals relative to each other were of a similar level of intoxication but both highly intoxicated?
Yeah, I think that does become, definitely becomes quite tricky. Obviously, in a sort of legal context, it becomes easier because it's only going to come up if one of those people reports it, and then it sort of automatically goes to, okay, well, we'll look at this through that lens. But I do think there is something there if both people genuinely are as sort of out of it as each other. That to me feels like something where we shouldn't be saying, oh, one person has violated the other. This is sort of if you've both been sort of as capable of making a decision as the other. But I guess there's, part of the difficulty there is that sometimes the sort of consequences of those regrettable decisions are more pronounced for one party than the other.
I was going to say that.
I feel like you've got thoughts on this, Lauren.
Yeah, I was just going to say, I think maybe not more. At least in those situations, I guess that's when that broader context of that relationship becomes important. Who initiates drinking, who initiates getting drunk, is that feature of their relationship? How does that usually play out? What's the sex like? Like that broader. I think the questions and the framing that you have places, it's not just about that moment, and I think that is what I quite like about this. Let's look at the features of the relationship and try and create more freedom to negotiate within the structure of it, rather than just that in the moment. Is that?
Yeah, definitely. And I think as well, like you said, that feels like quite a different, or it feels potentially like quite a different situation if you've got kind of two people who maybe know each other a bit, have both just gone out and gone, oh, let's just get absolutely hammered. Both wake up the next day going, I don't really remember what happened, and genuinely both don't, with no sort of additional history between them. That feels like a much more kind of even scenario than if you have got that sort of broader history, or oh, well, maybe that person has sort of pressured or suggested, oh, why don't you drink them more, without forcing them to or spiking them, but nevertheless. encouraged it, knowing, oh, this is what I do all the time, or this is, or like, oh, I'm going to encourage that person to get drunk because I want something to happen.
Yeah, I know that they'll do that. They're drunk, so let's get them together.
Yeah, but yeah, it's definitely not like I say, still don't have a nice easy answer.
Sort of interested in the idea about the two cases and the deception, because if you look at other crimes, like, you know, old people allowing people into their house and then they commit, you know, distraction, burglary or fraud, and that's an area that I've been writing in. You know, the consent is negated by the fraud, by the words spoken by the offender. So I was kind of interested to see the outcome of those two cases, because they sound to me like they both come under the guise of deception. And is it just because in the Monica case, the officer happens to be an undercover officer, so the agenda is let's not prosecute him? You know, what was the outcome for that one?
Yeah, so I think that was definitely a big factor, and yeah, they don't prosecute him, and the court upholds that was the right decision not to prosecute him. And it was very much a kind of test case to see if they could bring charges against any of the many other undercover police officers that had done similar things. One of the things they talk about in the judgment is that, oh, well, if we say that this is rape, then like kind of almost anyone having an affair or anyone who's got sort of a secret second family, then that would suddenly become rape. And that's just bigamy. That's a separate, less serious crime. We've already got something to deal with that. So I think definitely the fact that it was a police officer played into it and just.
But it sounds like we've closed the door on that now, because I used to do work with student police officers on undercover operatives, and since 2013 we've changed the law now. They're not allowed to have sexual relations, so it's almost like let's not prosecute all them, and let's make sure it can't happen again.
Yeah, and I think there have been other charges brought around sort of misconduct in public office, and also like various kind of inquiries which have criticised that, like that way of doing things, and led to those kind of changes. But in terms of being prosecuted for rape, they've said, oh no, this doesn't count. And what it's then done is, so there are other sort of non-police officer cases. So like there's a case where a guy lies about having had a vasectomy, and initially that's treated as, yeah, that is a case of rape. She didn't consent, you removed freedom to choose. And then on appeal, partly because the appeal is after that Monica decision, they take a much more restrictive approach. Part of the problem is also that there used to be a separate offence of procuring sex by deception that just sort of got forgotten about in the 2003 reforms. Like there's no discussion of it in any of the kind of Home Office reports or anything like that. So it doesn't seem like it was a kind of clear, deliberate decision of we don't want that offence anymore. It just sort of never made it into the act and just disappeared somewhere. So now we've got all these cases that like used to have somewhere to go and now don't. Yeah.
I think there's one in the chat. So.
I was just, I'm going to throw like a lot at you right now. I'm just interested because you talked about like children, and within that like kind of two things. One is like the idea, which is sometimes used as an excuse, but sometimes potentially genuine, the idea of like someone lying about their age. So a younger person lying about their age to say they're 16, 18, to have sex with an older person, and kind of where that comes in on like the freedom to negotiate, because it's almost like, well, the older person's been deceived in that situation, but the criminal responsibility would still be on them. And if like they meet in a club, it's like, well, they don't have any reason to believe that this person is not of age. And then also like wider non-legally, like legally everyone's of age to consent, but there's like an age gap or maybe a power imbalance. So yeah, I don't know.
Yeah, I mean, I've been thinking about this a lot, particularly after obviously all the stuff came out about Russell Brand, for example, and one of the, or like perhaps the most attention-grabbing part of that was this relationship that he'd had with a 16-year-old who was still at school. And from like from her descriptions of that, there were clearly like encounters within that relationship that just were straightforwardly non-consensual, and under the existing law would be recognised as such if it was, or at least should be if that law is applied properly. But it raised these bigger questions of like, well, what about the relationship itself, even if there weren't these specific encounters where he'd, kind of forced a particular sexual act. I think she herself has kind of said, oh, there should be some sort of age gap or something like that. And again, I think this kind of like freedom to negotiate idea is quite helpful there for thinking about, rather than saying, oh, well, she just wasn't capable of consent, looking at this particular relationship and saying, well, if you're a teenager with someone who's 35, incredibly wealthy, incredibly famous, do you really have a choice about whether to agree to any of this stuff or not? Are you really in a position to negotiate your participation in that sexual activity when you're so much younger, so much less experienced, have so much less sort of social capital and the rest of it? I think it allows us to look at those situations in a way that a mere sort of consent, either she can consent or she can't, doesn't really allow us to get into. And yeah, I'm thinking as well about, I guess that's not to say that I would want, we just look at every case on a case-by-case basis. I think you could still have a sort of built-in presumption of like, if this person is under this age and the other person is, a year or 2 years or whatever older than them, there is definitely no freedom to negotiate, and we just presume that in the same way that we presume children under 13 can't consent. But I would want that to have more of a recognition of like, who are they negotiating with, rather than it just be based on age, be based on age sort of relative to the other party.
I think you hit it on the head there, because if you look at child sexual exploitation, the biggest problem with social workers and police officers is the restriction into looking at the age of the girl who's being exploited in Rotherham and Rochdale. And you look at that literature, it's all, she's over 16, she can consent. No, she doesn't consent to being raped by about 5 40-year-olds. They're not looking at the power differential between the participants. They're simply looking at age.
Which happens with like drunken consent, right? The focus is always on how drunk, the alcohol. It's never on the wider context, the wider power. But I think the problem, it's not a problem, it's a good problem to have with the freedom to negotiate, is that it shines a light on power in society, right? Like, we don't have a lot of freedom to negotiate our lives in a lot of spaces. So it starts to bring to light all of the nuances that play out in positions of power and people that have less freedom to negotiate constantly. Like, I can see the resistance being that, like, no, it's better to just have like this is this, because otherwise it's like that philosophical question of like, how does this sort of like, what does this mean for our day-to-day freedoms?
And I think just coming back to that, sort of what I initially said about that quite fraught kind of relationship with the criminal law and criminalisation, is that's also my kind of concern, that this ends up being like, well, everything's just a crime, it's all like all of these bad relationships are all terrible, criminalise them all, which is not really the path that I want to go down. And part of this, like, certainly hopefully part of this is about pulling some of that back. Like, I don't think McNally should have been criminalised. I don't think, two young people who are peers engaging in mutually desired sexual activity should be criminalised. And again, a lot of the stuff around sort of like the law around mentally disordered adults is a lot better than it used to be, but is still is really sort of stigmatizing and subjects people on the basis of a disability to a much more intensive kind of scrutiny and control in ways that aren't necessarily based around sort of empowering or supporting or opening up those people's kind of freedom and access to a fulfilling and whole life, rather than just this very narrow kind of, you must be protected, these things are bad for you, based on this very individualised assessment of your capacity. Sorry, I was have a question.
Saskia says, I love your work.
Thanks
so much for the talk. How amenable is the law to change?
I mean, I think this in particular, it's probably quite a tough sell. Although, like, it's funny though, because I've been working on this for so long. When I started it, I was kind of like, oh, you know, the Sexual Offences Act was still relatively recent. And I was kind of like, oh, they're not going to want a big change anytime soon. Whereas it's been quite a long time now. We might be sort of getting to the point where it's time to look at some of this stuff again. There's certainly, I think, appetite for change around the deception cases in particular, because there's just been so much criticism of those cases, and the law is just a mess. Sort of every time there's an appeal decision, like every time you think there's maybe some solid principles emerging, even if you don't quite agree with them, there's another appeal court decision, and those principles get sort of chucked up in the air and fall down in a slightly different way. So I think there's maybe scope for something, or I think there's probably more amenability, is that word, to change in that specific area. I think to really kind of wholesale get rid of consent, probably a bit more of an uphill battle.
Thinking about that, do you think that, like, even if we change, like, if they were to accept this approach, do you think it would really make an impact, given like the barriers that there is to even being like heard as a victim, and like the low prosecution rate? And do you think that like how would that interplay if we changed how we understand things?
Yeah, it's definitely part of a bigger picture, and I know see a lot of people are kind of focusing on that kind of side of things, like police investigation and like trial procedures and that kind of stuff. But I guess where I come at it from is, yeah, that work is all really important, but actually there's something like more fundamentally wrong with the legal framework itself, and we kind of need to get that right, in addition to all of that more sort of practical stuff. I guess I think also in part of the reason why it's helpful to have some of these conversations with people outside of law is that, and part of the reason I've tried to think of this as both sort of an ethical framework and a legal one, is that, you know, I have sort of thoughts about how this could help in specific kind of legal cases. But even if the law never changes, this might be a useful way to change some thinking, to think, and particularly in sort of sex and relationships education and those kind of avenues, a way to sort of start to shift how we think about what kinds of sex are okay, or with whom, or in what circumstances, that shifts us away from some of that kind of problematic, kind of individualised consent thinking. Yeah.
I'm just wondering if it's worth rethinking, holding on to consent, but reframed or reimagined, expanded, something like situated consent. If that would work and have some traction, because consent's out there already. We're trying to come up with a new concept and be more difficult. And that situated consent would incorporate various interlocking contexts which are relevant. I mean, has anyone tried that?
I've not seen that kind of specific construction in the kind of legal stuff, but I think you're right that sort of shifting the language a bit and reframing it a bit might help in that kind of specific like law reform capacity, might be slightly more able to get people on board with some of the same ideas if it's kind of Trojan horsed in under language that they recognise and that are sort of okay with. And I guess I have sort of mixed feelings on that. And on the one hand, I can see that being quite a kind of useful and practical way to get more people, and particularly lawmakers, on board with it. I guess my sort of caution, or for me the upside of having a completely new language or new terminology, is that because there is this kind of consensus around consent already, it's a real like double-edged sword. On the one hand, that means like frame it as consent, people will be on board with it, but on the other hand, it means everyone kind of already thinks they know what consent is, and so having a kind of new terminology sort of forces people to go, oh, I need to actually find out what does this mean and have some kind of clear direction on that. So yeah, it's a real I feel like I've used the word tricky a lot. It's become like left problematic behind. Now I think it's tricky. But yeah, definitely worth thinking about. Thank you.
Any more questions? Thank you so much, Tanya.
That's quite all right.
Give you another clap. I think that the thing you said really early on about the like no means no, yes means yes, is like a really powerful like statement and reflection of like how we've not really moved on, and that like gendered like that like real deep seated like I'm still answering a question. I think was like a good fun. Yeah. I'm gonna use it. I'm just letting you know now, so
also, I'm really happy for Jessica to send those slides around if anyone wants them.
Cool. Yeah, I actually recorded that too. I think it actually worked.